Hungry Snacks Meals in the building.
I wasn't even thinking about me being on the show. I wanted to produce something for them.
Cool celebrity. Like if I went to the mall and stuff, people were like, oh,
The thing was, I didn't even know that anybody ever thought I was ugly.
We look like twins almost.
Okay.
She really wouldn't be able
Covering any more subjects related. So that's why you got the raw reaction. This is pathetic. It's pathetic. Hey y'all, hit that like button, hit that like button. Hit that like button. Hit that like button on the way in. Hit that like button. Hey, hit that like button. Hey. What's up, y'all? It's Friday. Y'all ready for a good show? Let's go. Hey. Let's get it. Let's get it. Hey. Let's go. Let's go. Let's go. Let's go. Come on, y'all. Come on in. I'm going to give y'all some more time. We got 30 people. Let's go, y'all. Let's go. Hey, what's up, CR? Oh, I didn't check the DM. I'm sorry, boo. Hey, Jackie Webster. Let's go. Let's go. Let's go. Hey, Vanderveer. Hey, Monica. Hey, Alice. Mama's in the building. Hit that like button. Hit that like button. You better stop fronting. Hit that like button. Hey. Let's go, let's go. What's up, Jasmika? Hey, boo. Y'all ready for a good show? We gonna show out tonight, y'all. Let's go. They signed this shit at 11:59. They answered to this case at 11:59. Nicki said, you ain't gonna get no 20 million on my watch, bitch. Alright, we got 34. Come on, y'all. Let's go. Get them likes up. Lovely Libra. Hungry Snacks Meals in the building.
I wasn't even thinking about me being on the show. I wanted to produce something for them.
cool celebrity. Like if I went to the mall and stuff, people were like, oh,
The thing was, I didn't even know that anybody ever thought I was ugly.
We look like twins almost.
Okay.
She really wouldn't be able
Covering any more subjects related. So that's why you got the raw reaction. This is pathetic. It's pathetic. Welcome back to the Sweet Pea Diaries. It's your girl Sweet Pea, and I am back with another video. If you are a returning subscriber, welcome back to my channel. And if you are a new subscriber, welcome to the Sweet Pea Diaries. Be sure to like this video, share this video, but most importantly, be sure to subscribe to the channel. Happy Friday, y'all. We made it through another week. It's Friday. It is Friday. We made it through another week. God has blessed us to see another weekend, to see another Friday. We made it all in one piece. Ain't nobody get fired this week. Ain't nobody get fired. If you made it through the week without getting fired, say amen. God is good. If you made it through the week without getting fired, say amen. God is good. Y'all, thank you so much for being here. You know, we do these updates with Nicki Minaj with this lawsuit. You guys know that we just recently started covering it. And like maybe a few days ago, the last that we heard, Nicki Minaj and Kenneth Petty had not answered to the lawsuit. Child, and Jen was about to she was about to win by default, okay? She was like, run me my coin, okay? Run me my 20 mil, okay? She said, run me. Thank you guys for the compliment. Thank you for the jacket compliment. Thank you very much. Yeah, you know your girl. Y'all know I picked this up at a little shop in a local mall that we have around here. I picked this up and one that I had on yesterday. Honey, I love it. It's giving biker girl. Let me let you see this thing. Because I just can't come up here and act like I ain't got on something that's far. Okay, yes. Y'all like it? Yes. You know, it says up and up. You know, it zips up and down. And it says respect. It was all a dream. I used to read Word Up magazines, salt and pepper deep on the cover. And then it says loyalty. You know, it's giving bikerish. It's giving bikerish. You know, I had to wear something pink and Barbie to represent Nicki. You know, I had to, pay homage to Miss Nicki Minaj. So I had to try to get pink. Thank you, guys. Oh, you love pink as your favorite color? Okay. Yes, girl. So I tried to get as cute as I can get. You know, I said I'm going to try to do a little pink, something pink to go with Nicki Minaj. So we're going to let this down a little bit, because if not, I'm going to fall out, child. I got to let some heat in this mother. Got to let some air in this. Get this. We got to get it popping. All right. So, yes, it would seem that Nicki and Kenny, at 11:59, they chose to respond to this lawsuit. Because like I said, child, Jen said, run me my coin. Okay. Jen, run me my coin. So Nicki and Kenny, they decided to respond. All right. Like I said, at 11:59, after being served, they have decided to respond. So, of course, I got those court documents and we're going to take a look at them. Okay. So let me get these docs and we're going to get this show on the road. All right. Yes. We're going to get this show on the road. All right. Yes, ma'am. So Miss Jennifer Hough, we all know she is suing Nicki Minaj and Kenneth Petty for harassment for the sexual assault case that occurred back in the 90s between Kenny and her. On her way to school, we all know the story. On her way to school, Jen was on her way and Kenny assaulted her and raped her. So she is suing for emotional distress because as a result of that, Kenny had to register as a sex offender after serving time in jail. Once he was released, the requirements was that he register as a sex offender. Anytime he moved, anywhere he, goes outside the state and moves and takes up residence in another state, he has to register as a sex offender. Well, when being married to Nicki Minaj and getting with Nicki Minaj, in 2019, he traveled to California with his wife. And once arriving there and taking up residence in her home, he did not register as a sex offender. So he was arrested. He was found to be guilty because he filed that he was guilty. When answering to that, he pled guilty and he took a plea deal. Now, in consequence, prior to that, Jen was receiving harassing calls, messages. She had to move several times because she was being threatened by, allegedly being threatened by Nicki Minaj, Kenny, their goons. She was being offered money, to recant her story so that Kenny could get off of the sex offender registry. Because now that he's married to Nicki Minaj, he doesn't feel as though he needs to be a criminal anymore. He doesn't need to be on the registry because he wants to be able to travel. He wants to be able to go with his wife on tour. He wants to be able to go to the clubs. Now that they got a baby, he wants to be able to go on down to the schoolhouse. He wants to be able to live a normal life. And I get that. Definitely. I mean, I'm all with you do the crime, you do the time, and you should be able to go on and live your life. However, you don't get to change rules just because you're rich and famous with a rich and famous wife now. If she wasn't your wife and if he wasn't with Nicki Minaj, he would still be registered as a sex offender. He would still be going about his everyday routine, his everyday life as a sex offender and registered on the list. But because now that he's with her, he feels as though he want to have privileges like any other man would have and be able to come and go as he pleases. But you're not any other man. You are a convicted rapist, period. And then when the argument is that, oh, well, he was convicted of attempted rape. Yes, because he took a plea deal. And when you take a plea deal, they knock down the charges so the severity, the punishment can fit the charge. You think if you're convicted of first degree rape that you're going to be out in 4 years? Hell no. So when they give you a plea deal and they offer you a plea deal, part of that is that they lower the charge. They lower the charge. So that is why attempted rape is what he was found and convicted and guilty and did time under, convicted and did time under attempted rape because of the plea deal. Anyone that been in the system, anyone that knows anything about the legal system, when you plead guilty and you take a deal, they will usually reduce the charges to take the sentence down. All right. That's the only way he was able to get the little time that he did and was able to get out in a short amount of time. Now, his argument is also that while he was incarcerated in 2004, he was, someone signed paperwork and about him not wanting to show up and I guess plead his case about being a sex offender. So they left him on the registry. Someone forged his name, signed those documents. They didn't know that he was in jail, but that don't make no sense to me because when you're on the sex offender registry, you're on parole, probation, all that. Any move you make, these people know where you are. So he said that they didn't know that he was locked up. In consequence, they sent the paperwork to an address that he was not residing at. He was in jail and someone forged his signature. So, he's suing the state of New York. So there's a lot going on and there's a lot to unpack when you get into this Nicki Minaj, Kenneth Petty, and Jennifer Hough. All right. So pulling up the court docs, I'm going to show you guys where, and I took the liberty of blotting out Nicki Minaj's address because I do not want to be doxing people. I did not want to show her address or anything like that. So I took the liberty to blot out the address. All right. So Jennifer had Nicki and Kenny served. Okay. They were served in September and they had a certain amount of time to respond. All right. You guys know it takes a minute to get these docs. All right. Give me a second. All right. All right. So on September 13th, Nicki Minaj and Kenny were both served. All right. The documents were drafted. by the lawyer, and Nicki and Kenny were both served on, they drafted up the documents on the 13th. The summons was given to, the person that's going to go and serve you. And they actually served Kenny and Nicki at the same time on the 16th of September at their home addresses. All right. And here that goes. All right. So this shows the actual summons. All right. This is proof of service. This is a summons for Kenneth on 9/15 at 6:25. I blotted out their address. Robert Diaz was the server. This was drafted up in front of him on 9/13. He received it and it was given to him on 9/13. He signed for it and he executed it and gave it to Kenneth, aka Zoo, 9/15 at 6:25. He also served Nicki Minaj at 9/15, 6:25. I blotted out their address. So they were both served on that day. This is the summons. The lawsuit was served to the both of them. And this is what was given to them. This is the actual summons. Summons in a civil action. It says Onika Tanya Mirage, aka Nicki Minaj, and Kenneth Petty, aka Zoo. It says a lawsuit has been filed against you. Within 21 days after service of this summons on you, not counting the day you received it, or 60 days if you are in the United States or a United States agency or an officer or an employee of the United States, you have 60 days. You must serve on the plaintiff an answer to the attached complaint or a motion. The answer or motion must be served to the plaintiff or the plaintiff's attorney. If you fail to respond, judgment by default will be entered against you for the relief demanded in the complaint. You also must file your answer or motion with the court. So this was given to them on 9/15 at 6:25. They had 21 days. And the actual date of expiration, I'm going to give that to you so you can see that everything I'm saying I'm not making it up. I'm going to show you the date that they had to respond. Okay? Because remember, the last video that we did, I wasn't able to show you this receipt because I didn't blot out the address. So I couldn't show you the actual lawsuit being served to them. But I blotted it out so that you guys would be able to see it. All right. So the actual time period that they had to respond, it said answer due by 10/6. All right. So answer due by 10/6. So as you can see, the answer needed to be turned in by 10/6. All right. That's these two little summons due by 10/6. All right. And we know that they did not answer. They had not answered by 10/6, which was why Jen then asked the judge to find on her behalf. She wanted them to issue a judgment by default because they had not answered. Okay. And we went over that, and give me 1 second. Give me one moment to get that receipt. Okay. So many. Okay. All right. So Jen wanted the court to issue on her behalf. She wanted to enter a judgment. So she said, please enter the default of defendants Nicki Minaj, and Kenneth Petty for failure to plead or otherwise defend this action, as fully appears from the court file herein and from the attached affirmation by her lawyer. So she wanted them to find in her favor because they had until 10/6 to respond and they did not. So she was asking for, as we saw in the documents, $20 million. She wanted the judge to rule in her favor because they had not said what they intended to plea and they had not answered to it. So all of the people that was in the chat talking about Nicki didn't answer to it because she didn't care nothing about it, and she didn't have to answer to it because she didn't care and it didn't mean anything to her. You are required to answer to a lawsuit when it is filed against you. I just showed you that paperwork. You have 21 days if you're a normal civilian. You have 21 days from the date it was served to you to answer. Or if you're a federal employee or something like that, you got 60 days. So we know that Nicki and Kenny are not no goddamn federal employees. So they had 21 days, which that expired on 10/6. And as of 10/6, nobody had heard anything from Nicki Minaj or Kenneth Petty. They were on social media arguing about the vaccination. They were on social media showing off that Nicki Minaj is going to be hosting the Real Housewives of Potomac reunion. And if I'm not mistaken, that came out around 10/6. So magically, all of time, Nicki deflects around the time that there's something due. There's something to be responded about this lawsuit. So instead of responding or showing that she cares about the lawsuit at all, she tries to give her ass to kiss by doing press, deflecting, showing us other things. Andy Cohen and Real Housewives of Potomac. When you are being required to answer to a lawsuit for $20 million, it's the barbs for me that are delusional, saying Nicki don't care nothing about it. That's why she's not responding. Well, according to the law and according to how the legal system works, you are required to answer to a lawsuit. I don't give a damn whether you care about it or not. I don't give a damn whether you want to be sued or whether you think you shouldn't be being sued. That's not the way the legal system works, and that is not the way the justice system works. You are required to answer to the lawsuit respectfully. So as of yesterday, magically, we now have a response from Nicki Minaj on the 14th, not the 6th, the 14th. On the 14th. So, appearance of counsel. This was filed in the court, the clerk, I always get that, the clerk of court's office. I admitted or otherwise authorized practice in this court, and I appear in the case as counsel for Nicki Minaj. This is her lawyer. He entered her answer on the 14th. Nicki didn't do it, of course, why not? Why would she show up? She had her lawyer show up and enter her answer or what she intends to do. Right? And trying to get that paperwork, it's right here. Woo. All right. Now here is notice of motion. This is filed to Jennifer Hough and her attorney in the Eastern District, New York District Court. Please take notice that upon the attached declaration of defendant Onika Tanya Mirage executed on October 14th, 2021, the annexed declaration of Judd Bernstein, that's her lawyer, executed on October 15th, that is today. And the exhibits annexed thereto, the accompanying memorandum of law, and all prior proceedings heretofore and herein the undersigned on behalf of defendant Onika Tanya Mirage will move this court before the Honorable Eric N. Vitiliano, United States District Judge at the courthouse located at 225 Cadman Plaza East, Brooklyn, New York, 11201, on a date and time to be set by the court for an order granting defendant leave to file what plaintiff contends would be a late pre-motion letter as required by the court's individual practices. So Nicki Minaj's attorney is asking that she be granted a leave, basically more time, extension of time to answer to this lawsuit. Even though she's answering it late, they contend that it would be late. Okay, but they already gave you 21 days. Why do you need more time? You had 21 days to say what you intended to do, but whatever. So Judd Bernstein declares under penalty of perjury pursuant. So basically what they're asking for, they say, okay, can we have more time to enter in our answer? This is her answer. But because she's filing late, she's asking, can I have this submitted? Will you hear what I have to say? Even though I filed it late, will you please listen to what I have to say? Because it is late. So they submitted an extension of time as well as their answer all at the same time. Okay? So I am attorney, blah, blah, blah. I submitted this declaration in support of defendant's motion, seeking leave to file a late letter requesting a pre-motion conference in anticipation of a motion to dismiss the amended complaint pursuant to federal rule, blah, 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 blah. And then they just start talking about email correspondence. And so they say, annexed hereto as Exhibit A is a copy of the proposed pre-motion conference letter, which defendant seeks leave to file with the court. Annexed hereto, Exhibit B is a copy of my October 13th email correspondence with plaintiff Jennifer Hough's counsel. Annexed hereto as Exhibit C is copy of an October 14th article posted on the Daily Beast. So, child, let me tell y'all, I got receipts, okay? We get ready to be looking at exhibits, all right? We get ready to be looking at exhibits. Matter of fact, we get ready to be looking at exhibits. Let's take a break real quick. Let's take a break.
All right.
All right, y'all. Let's get it popping. We getting ready to look at these receipts. Y'all know I had to get my my allergy medicine together, child. I had to get these sinuses together so that way I would be able to finish off the rest of this video. Okay. So yes, honey. Boom. Boom. So she says they have submitted Exhibit A, B, and C. I confirm the truth of those portions of defendant's declaration concerning my role in her failure to secure my services promptly. I declare under penalty of perjury that the foregoing is true and correct. Executed on October 15th, 2021 in the state of Connecticut, Fairfield. So I guess that's where her lawyer is from, Nicki. All right, so Exhibit A. Exhibit A. Dear Judge Vitiliano, this is Nicki's letter that she's writing to the judge asking for leave because she was late, so she want more time to be able to submit her answer to the amended complaint. And this is what she is proposing. Pursuant to Section 3A of Your Honor's individual practice and rules, I write to request a pre-motion conference in advance of a motion by defendant Onika Tanya Mirage to dismiss the amended complaint pursuant to federal rule, blah, blah, blah. Given the 3-page limit for this letter, the following outlines just some of the amended complaint's failings. Should the court permit defendant to file a motion to dismiss the amended complaint, there are multiple additional arguments which she would pursue. So this is why she wants to dismiss. The amended complaint should be dismissed pursuant to Rule 12b-3. When a defendant moves to dismiss a complaint under Rule 12b-3, the plaintiff has the burden to establish that venue is proper. Then they talk about Hansen versus Miller, and they always give examples of cases when they're trying to use this rule. So they talk about that case. Since paragraph 12 of the amended complaint alleges correctly that defendants are both residents of California, venue would be proper here only if plaintiff Jennifer Hough had adequately alleged that a substantial part of the events or omissions giving rise to plaintiff's claim occurred in this district. So they are disputing the fact that what she's stating happened to her did not happen in California. So they are saying the venue, it should not be in California because nothing happened to her in California. In the first instance, plaintiff has not met her burden because the amended complaint does not allege any basis for a venue in this district, instead stating only that plaintiff felt the bulk of defendant's actions in the states of Georgia and New York. So she's saying because they don't live in Georgia or New York, how is it that this is relevant to them threatening or harassing her? Because she said she felt the bulk of her actions happening to her in Georgia and New York, and they don't live in Georgia or New York. They live in California. This allegation does not support venue because 1391b2 requires that events took place in the relevant district. I note my belief that there appear to be compelling reasons to dismiss the amended complaint under Rule 12b-2. Pursuant to my Rule 11 obligations, though, I am not pressing this argument now, as I need to undertake some additional investigation of the facts and law. However, defendant does not intend to waive a claim that the court lacks personal jurisdiction over her by reason of not discussing it in this letter. Turning then to the alleged events in the case, plaintiff's is undoubtedly resting her venue claim upon the fact that the attempted rape for which defendant's husband was convicted occurred in Queens County. However, the location of that event is irrelevant to the issue of whether venue as to the defendant is proper, because when venue is challenged by a defendant, plaintiff bears the burden of proving that venue is proper in the forum state for each claim against each defendant. Given the page limit for this letter, I cannot detail each of the amended complaint's minimal allegations against defendant, but that they may be found at paragraphs 82, 84 to 85, blah, blah, whatever. Not a single one of these allegations even remotely suggests conduct in New York. The lack of any connection between these allegations and the Eastern District of New York is further demonstrated by the fact that the three claims for relief asserted against defendant in the amended complaint, counts 5, 6, and 7, all seek relief only under California and Georgia law. If plaintiff were alleging that defendant engaged in any conduct in New York, she would have also sought relief under New York. The complaint should be dismissed pursuant to Rule 12b-5. Once a defendant moves to dismiss under Rule 12b-5, the plaintiff bears the burden of proving adequate service. Here, defendant has made an evidentiary showing that she was not properly served. So Nicki is trying to say that she was not properly served. The affidavit of service filed by plaintiff, docket number 14, states that defendant was served via personal service of a copy of summons and complaint upon her husband, who is described as a black male, 40 years old, 20 pounds, black hair, brown eyes. Defendant, however, has executed a sworn declaration in which she states that the process server is not telling the truth, as this never happened. In fact, my husband is 5'9" tall and weighs no more than 175 pounds. Ooh, they lying. They're trying to say that they did not get served. That the server is saying he served a black male, 40 years old, 200 pounds. But Kenny is 5'9", 175 pounds. Further, there's no person who resides in our house or who was present there on September 15th, 2021, who fits the description contained in the affidavit of service. The complaint should be dismissed pursuant to Rule 12b-6. This complaint should be dismissed because the three claims for relief asserted against defendant are almost unintelligible and certainly not sufficient to withstand a motion for dismissal. The Queen Radio referenced in paragraph 84 of the amended complaint refers to the name of an Apple Music show, not Queens, New York. Okay, what does that mean? We know that. We never said that. We said Queen Radio, that she made these statements on Queen Radio. See, this is the manipulation tactics. This is what you pay high-price attorneys to do, though. They try to manipulate words. Alternatively, pursuant to 28 U.S.C. 1406A, this case should be transferred to the Central District of California, which is the district in which both defendants reside. Count 5 alleges that defendant engaged in harassment and witness intimidation under California and Georgia law. The claim under California law is facially frivolous because plaintiff is seeking damages for a violation of California Civil Process 527.6. That statute, however, provides only for injunctive relief. Dismissing a claim under 527.6 because the statute does not provide for an award of damages. As for plaintiff's reliance upon a supposed Georgia's harassment statute, there does not appear to be one that gives rise to a civil remedy for damages. Civil liability may only be authorized under a penal statute when the General Assembly has expressly provided for a private right of action in the textual provisions of that statute, not extrapolated from the public policy the statute generally appears to advance. So they're basically using different statutes and cases that fall under these statutes to try to wriggle their way out of this lawsuit. That's basically what's happening here. They're trying to pick apart all of the, rightfully so. That's what an attorney does. When you're a defendant and a plaintiff, no matter what side you're on, that's what lawyers do. That's what they pay high-priced lawyers to do. Try to find loopholes and try to find ways out of a lawsuit. And that's basically what is happening here. This is the type of shit that Tasha K needed. She needed a lawyer that was going to be able to try to find loopholes, because that's the only way that they would be able to wiggle their way out of this lawsuit, is by lying like they did, saying that they were not served. You have to prove that you actually served them. And we know that that can't be proven unless it was videotaped. Did the server videotape it? No one. Who was thinking to videotape it? Who would think that someone would try to manipulate and say that they weren't really served when they know they were? And I want to see when Nicki Minaj was served, who was that? One of your maids? Because you both were served at the same time on the same day. So who served Nicki? Or was it Nicki? Oh, you're going to say it wasn't you. It was one of your maids or one of your assistants, because y'all wasn't there on September 15th. But why didn't you answer to the lawsuit? Why did you wait until it was expired? Oh, because you're so busy. You're a celebrity. You don't know that you have a lawsuit filed against you. But you're not reading the blogs or any of that, right? You didn't see her on The Real. None of your assistants, none of your PR, your label, your lawyers, nobody told you that you had a lawsuit filed against you. Your fans, everybody saying it in the DMs and the comments, all this shit, you didn't know. So that's why Nicki didn't respond, because she's the type that doesn't pay attention to social media. That's what y'all be thinking. They kill me with this thinking that because people are celebrities that they don't see videos. Like they ain't gonna run across an Armand Wiggins video or a Sweet Pea Diary video. Oh, they don't watch it because they're so famous, they're so celebrity-fied that they don't watch none of our shit. They turn on YouTube and they find videos and run across content just like the next person. There is no certain internet or no certain YouTube or no certain Instagram for celebrities that is different from what the hell we got. They see every goddamn thing that we see. They run across videos just like we do. They scrolling, looking through comments. Nicki Minaj was served and so was Kenny. But they're trying to lie their way out of it and wriggle their way out of it. And they paid a high-priced attorney to lie. They paid a high-priced attorney to try to find loopholes in laws and try to wriggle their way out of this lawsuit. That's basically what we're reading and what's going on here. Count 6 of the amended complaint alleges that the defendant is liable for aiding and abetting under California and Georgia law. This claim is incomprehensible because the claim that a defendant was aiding and abetting another person is meaningless unless the plaintiff also identifies the underlying conduct which was supposedly being aided and abetted. Here, the amended complaint fails to do so. So what they're saying here is when Jennifer is filing this lawsuit, part of it is in the filing is saying that Nicki Minaj aided and abetted Kenny. She was aiding and abetting Kenny, like hiding him or going along with the narrative, with the harassment. She was harboring basically a fugitive, knowing that he was supposed to be registering as a sex offender, and was allowing him to harass, intimidate, bully, send people, threaten, all of that. So she was aiding and abetting Kenny because she was partaking and allowing him to partake in this type of activity. So they're saying, the lawyer is now saying, what you got to prove, what was Nicki Minaj doing that aided and abetted Kenny? What actions did she display that was aided and abetted? You got to prove that. What was she doing? What did you see her physically do that was aiding and abetting? That's what that count. They want to dismiss based on that you can't prove that. What was she doing that was aiding and abetting? Count 7 of the amended complaint alleges that the defendant should be held liable under California and Georgia law for intentional infliction of emotional distress. The allegations against defendant in the amended complaint do not remotely make out the elements of that tort under either California or Georgia law. That all of the claims made against defendant are brought under California. Okay, all right, so that was ended that. And so it says, Judd Bernstein, her lawyer, is asserting that all of the claims made against Nicki Minaj should be brought under California and Georgia law, raises issues concerning whether a defendant can be held liable for acts committed outside of a state simply because a plaintiff felt the effect of the acts there. Again, Judd Bernstein, that all states that all of the claims made against Nicki Minaj are brought under California and Georgia law, raises issues concerning whether a defendant can be held liable for acts committed outside of a state simply because a plaintiff felt the effect of the acts there. So because Jennifer is saying that most of the emotional distress took place in California and Georgia, or was it, wait a minute, let me get that right. Let me make sure. Yes. Because she said that's where she felt most of her. She's okay. So plaintiff felt the bulk of Nicki's actions in the states of Georgia and New York. But see here, they flip it and they say that all of the claims made against defendant are brought under California and Georgia law. They don't say anything about New York. It raises issues concerning whether a defendant can be held liable for acts committed outside of a state simply because a plaintiff felt the effect of the acts there. So Nicki and Kenny live in California. So Nicki, what I believe they're doing is trying to get the venue as California. And she's saying none of this shit happened in California. So that's what she would want it dismissed. It's a lot of trying to go around the law and try to find loopholes. That's what this is. So plaintiff appears to be contending that as a victim of a tort committed against her in state A, she can sue the wrongdoer under the law of state B 10 years later because she has continued to suffer from the effects of the tort after moving there. This makes no sense. So now, this now is Exhibit B. This is an email from Tyrone Blackburn, which is Jennifer's lawyer. This is sent to Nicki Minaj's lawyer. Judd, you can file your opposition and explain to the court why your client believes that her and her husband are above the law. I do not consent to an extension. And that was in response because Judd Bernstein reached out to Tyrone Blackburn and he sent in an email. I expect to file a notice of appearance tomorrow on behalf of Nicki Minaj in the above referenced action, all albeit without conceding that the court has personal jurisdiction over Ms. Minaj. I am aware that you filed a request for certificate of default on October 11th. I am writing to ask you voluntarily withdraw your request and agree to an extension of time until November 1st, 2021 to answer or move against the complaint. Otherwise, we will both waste our time litigating a motion on which Ms. Minaj will surely prevail. to set aside the default. Please let me know whether you will agree to my request at your earliest convenience. Let me tell you something. I'm about to decipher and what should I say? What's the word? What the word I'm looking for? Translate. I'm about to translate this bullshit. Okay? I'm about to translate this bullshit, and I got to show you my face to do this. Okay? Because Nicki Minaj, again, feels that she is above the law and she's got a high-priced attorney. She got her attorney reaching out to Tyrone Blackburn, to Jen's attorney, saying, we were late. We never answered to the lawsuit. And I am aware that on October 11th, you filed a motion asking the court to find in your client's favor by default because my client did not respond to the lawsuit. And we understand that she didn't do that. So we are asking that you voluntarily withdraw your request to win by default $20 million. And you need to do so because we're Nicki Minaj's counsel. And we're asking that you do that by November the 1st. Because other than that, we're going to waste our time. Tyrone said, hell to the no, 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 dab. Hell to the no, 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 dab. I dab on you hoes. I said I dab on you hoes. Tyrone said, you do what you got to do. We are not withdrawing shit. Hell no. Y'all go head down to the courthouse and file that paperwork. Go on down there to the courthouse and file that paperwork. We're not withdrawing a goddamn thing. You knew what you had. You knew what time period you had to answer. You knew what you had to do. And you think because you're Nicki Minaj, you are above reproach, that we need to just withdraw our default judgment by default request? Hell no. You had until October the 6th to respond. And by October the 11th, we filed a judgment by default. We waited 4 more days. We still waited 4 more days. We still waited until October 11th. You had October 6th. You still didn't respond. We waited, 5 more days. Still hadn't heard anything, so we filed. And now you want us to go on down to the courthouse and withdraw? And we need to, you going to tell my client, who is the one bringing this lawsuit, you going to tell my client what she ought to do when she's already suffered enough harassment, bullying, people telling her what to do, your client stabbing, jugging a knife in her belly at the tender age of 15 years old, your lying ass client, Nicki Minaj, trying to persuade the world and social media that Kenny was only 16 when this happened. He was 15 and Jen was 16. Jen was a white girl. They were both dating and she broke up and all these things, this narrative. And he didn't want to be with her no more, so she was upset and she brought these allegations against him. When you knew damn well that he took that girl into that house and he raped her. And even your attorney acknowledges it in your goddamn response. In your motion, in this response, he acknowledges that she was raped. He acknowledges it. Tyrone Blackburn said, hell to the no, no, no. You don't tell us. He said Judd. He didn't call him Mr. Bernstein. He didn't say Judd Bernstein. He said Judd. Listen, buddy. Listen here, sir. Judd, you can file your opposition and explain to the court why your client believes that her and her husband are above the law. I do not consent to an extension. Regards, Tyrone Blackburn. He said, you don't tell me what we need to do. We filed this lawsuit. I don't give a damn who your client is or who she thinks she is. The law is the law. You had 21 days to respond or answer to this lawsuit. You had 21 days to respond, period. And you did not. You did not. And look, he going to say in the bottom of his email to Tyrone, my apologies in advance for any typographical and or grammatical errors. I am a terrible typist and proofreader, particularly when I am drafting an email under time pressure. Well, that's on you, homie. And the computer got spell checked. The computer can spell check the shit for you. It can spell check it, and it can do grammatical checking. Don't try to butter up Tyrone. Tyrone don't give a damn about you being under pressure, under time pressure. Tyrone was straight to the point in response. Hell no, keep it pushing. He ain't got no key in here. He don't give a damn about your little PS at the bottom of this email. PS, my apologies in advance for any typographical and grammatical errors. Tyrone, like, get that shit up on out of here. We are in a lawsuit. We are enemies. Stop trying to butter up to me. This is giving, I'm trying to butter up. This attorney knows that they are under the gun because they are late. They did not answer to the lawsuit. It expired. They can be found liable for damages. You had until the 6th. You did not respond. It particularly says in the goddamn lawsuit, period. A lawsuit has been filed against you within 21 days after service of this summons on you. You must serve on the plaintiff an answer to the attached complaint or a motion of what you intend to do. The answer or motion must be served to the plaintiff or their attorney. If you fail to respond, judgment by default will be entered against you for the relief demanded in the complaint. You must file your answer or motion with the court. It does not say if you fail to respond, judgment may or could. It says it will be entered against you. If you fail to respond, judgment by default will be entered against you for the relief demanded in the complaint, and that was $20 million. So you mean to tell me that you want me to believe that Nicki didn't give a damn about this lawsuit, so she didn't respond because she didn't give a damn? No, she didn't take it serious. This is serious. You are wasting the court's time. This is a summons in a civil action, and you did not respond. By not responding, what did you think? It would go away? What did you think? That if this was a frivolous lawsuit, it wouldn't even be considered. It would have been thrown out. It wouldn't have made it this far. It would not have made it this far. Why did you not respond to this lawsuit? It definitely says within 21 days after service of this summons on you. If you do not answer the motion, it will be judgment by default, and it will be entered against you for the relief demanded in the complaint. So I don't see how anyone thinks that. Now, that's why they asked for an extension of time. They had to file the letter first along with their answer, because you can't just put the answer in late. You have to also ask for extension of time. So we need to know, what's your reason? Why didn't you? So that's going to be coming. The judge is going to want to know, well, what's your reason? They don't even give a reason as to why they were late, why they didn't answer. They don't have a reason. They have no reason. None of the paperwork that Nicki Minaj submitted has a reason as to why they are late. All she's doing is submitting information as to her exhibits and all of this shit. Now, Exhibit C is the article by the Daily Beast, okay? Nicki Minaj finally responds to Jennifer Hough's witness intimidation lawsuit, sort of. Minaj and husband Kenneth Petty have ignored his sexual assault survivor's lawsuit for months. The threat of a $20 million default judgment has finally caught their attention. Nicki Minaj and Kenneth Petty's harassment and witness intimidation case just took another turn. Jennifer Hough, whom Petty was convicted of sexually assaulting in 1995, recently requested a $20 million default judgment in her witness intimidation case against the couple after they failed to respond to her lawsuit. Hough's attorney, Tyrone Blackburn, says he received an email Thursday night from attorney Judd Bernstein on Minaj's behalf, in which he requested that Blackburn withdraw the petition and grant an extension to respond. I said no. Hold on, guys. In which he requested that Blackburn withdraw the petition and grant an extension to respond. I said no, Blackburn told the Daily Beast in an email. I told him to prepare his opposition to my request for default judgment and explain to the court why his client and her husband believe they are both above the law. So I don't understand what submitting this, this article. I don't understand what her lawyer or what they felt that, that I don't know. I don't understand what that is inserted in here for. So I don't understand what that is in here for. But this is declaration of Onika Minaj. Onika Tanya Minaj declares under penalty of perjury pursuant that the following is true and correct. This is her answer to this complaint and as to why she's late and everything. So this is her official answer. All right. Now we getting ready to get into the meat and potatoes. All right. I done took y'all up to the climax. Here it is. I am defendant in this case. I am advised that plaintiff has filed an affidavit of service from a process server who claims that my husband and I were served because he personally handed the summons and complaint to my husband, who he describes as a black male, 40 years old, 200 pounds, black hair, brown eyes. The process server is not telling the truth, as this never happened. In fact, my husband is approximately 5'9" and weighs no more than 175 pounds. Further, there is no person who resides in our house who was present or who was there on September 15th who fits the description contained in the affidavit of service. Now, here's what she says is why she did not respond to the complaint. My failure to respond to the complaint by the date which plaintiff claims was my last date to do so was the product of a series of innocent miscommunications. After learning about the complaint, I sought out recommendations for a lawyer in New York. On September 22nd, 2021, Mr. Bernstein was recommended to me, and we met on a Zoom conference the next evening. Thank you, peace and love, for the $5 super chat. She says she don't care. Had a whole party with kids around her pedo husband. Registered offenders can't be around kids. Arrest them both for that too. I know that's right. At the end of that conference, I believed that I had agreed to Mr. Bernstein representing me, and I told him to work out the financial details with my manager, Angela Kowalski. From that point on, I believed that Mr. Bernstein was my lawyer and that I would hear from him when he needed to speak with me. I note that I have not had extensive experience with court cases, and I did not know that I was at risk of a default while waiting to hear from Mr. Bernstein. I did not learn until October 12th when I received papers concerning a default that Miss Kowalski had not understood that I had approved Mr. Bernstein as my lawyer, and therefore he had not been retained. Mr. Bernstein was available to speak with me. He was not available to speak with me until the evening of October 12th, at which time the misunderstanding was cleared up and Mr. Bernstein agreed to represent me upon approval of a retainer agreement and the payment of his advance retainer. My failure to respond to the complaint was the product of an innocent mistake, and I asked the court to excuse the delay so that I can defend what I believe to be an entirely frivolous case which plaintiff's counsel has brought against me in an effort to use my name to generate publicity for himself. I declare under penalty of perjury that the foregoing is true and correct. Memorandum of law in support of defendant Nicki Minaj's motion for leave to file a late letter requesting a pre-motion conference in anticipation of a motion to dismiss the amended complaint. Defendant Nicki Minaj submits this memorandum of law in support of her motion seeking leave to file a late letter requesting a pre-motion conference in anticipation of a motion to dismiss the amended complaint. A copy of the letter which defendant seeks to file is annexed as Exhibit A to the accompanying we read that. Introduction. This case is founded upon defendant's husband's 1995 conviction for an attempted rape that occurred 27 years ago in 1994. The amended complaint does not allege that defendant Nicki Minaj, who was only 12 years old at this time and is now a hugely successful and famous recording artist, had any involvement in that underlying conduct. Rather, it alleges only that she engaged in patently non-actionable conduct, allegedly commencing in 2018, in response to plaintiff Jennifer Hough's demands for money. As against defendant, the amended complaint is just the next stage of plaintiff's efforts to extract money from the defendant arising out of conduct in which she had no involvement. It is frivolous and implausible and illogical. It is a illogical, factual, frivolous lawsuit. In truth, defendant has been sued for two reasons, neither of which are tied to the merits. First, as evidenced by the plaintiff, that plaintiff did not seek damages for harm suffered in 94 until after defendant publicly married her husband in 2019. So she's saying that Jennifer did not seek any type of money or anything about what happened to her in 94 until after Kenny got married to Nicki. And now that Kenny has money through Nicki, now Jen is suing her, trying to get her money due to what happened to her through her husband. And she has nothing to do with that. Second, plaintiff's counsel has named her as a defendant in an effort to garner media attention for herself. Defendant seeks permission to file a pre-motion letter instead of a motion because Section 3A of Your Honor's Individual Practice and Rules require that a request for a pre-motion conference be made before a motion to dismiss a complaint can be filed. Plaintiff counsel's motives are well demonstrated by the fact that due to Jennifer Hough's counsel pursuit of media attention, they're saying that Tyrone Blackburn wants media attention. Nicki Minaj has been forced to bring a motion concerning a dispute which should have been resolved by counsel without the court's intervention. So she's saying that they could have settled this between their attorneys and they didn't need to go to court. But why would you need to settle something through your attorneys if you didn't do anything? Why would you need to settle and go through attorneys if you didn't need to, you didn't do anything? On October 11, 2021, just 5 days after the date by which defendant would have been required to respond to the amended complaint if she had been properly served, which she was not, plaintiff's counsel filed a request for a certificate of default from the court clerk. Here is the summons that Nicki Minaj was served. Kenneth Petty was served. The husband and Nicki Minaj was served. So when the server gave these documents, he only gave them to Kenneth, or a male that fit the description of Kenneth, is what they're saying. This description was a black male, 40 years old, 200 pounds, 5'10", black hair, brown eyes. So he gave both of the summons to Kenneth. So what Nicki is saying, she was not served. She was not served. She's saying that both of the documents was given to a black male, and she's saying that that was not her husband. Same thing that they trying to say, he was not at the house when they sent those court papers there for the sex offender registry, that he was locked up and someone forged his signature. Plaintiff counsel responded as follows. You can file your, so it says just 2 days later, on October 13th, defendant's counsel sent plaintiff counsel an email asking him to withdraw his request for a certificate of default and instead agree to an extension of time just to November 1st, for which the defendant to answer and move against the amended complaint. Plaintiff counsel responded as follows. You can file your opposition and explain to the court why your client believes that her and her husband are above the law. I do not consent to an extension. But for what happened next, plaintiff counsel refusal to make a reasonable accommodation might be excused as genuine, albeit erroneous. Explain why she believes that her and her husband are above the law. However, subsequent events show that plaintiff's counsel refused to agree to defendant counsel request because he wanted to use it as an excuse to secure a media article for himself. Hence, the next day, October 14th, the Daily Beast posted an article about which plaintiff counsel surely planted. So what Nicki Minaj's attorney is saying is that they attempted to work this out with Tyrone Blackburn, saying, hey, we're late. Can you, remove your motion to win by judgment of default? And because Tyrone is after media press and media attention, he said no because he wanted to secure an article with the Daily Beast. And they're quoting in the Daily Beast, the article, Hough's attorney, Tyrone Blackburn, says he received an email Thursday night from attorney Judd Bernstein on Minaj's behalf, in which he requested that Blackburn withdraw the petition and grant an extension to respond. I said no, Blackburn told the Daily Beast in an email. I told him to prepare his opposition to my request for default judgment and explain to the court why his client and her husband believe they're both above the law. Obviously, plaintiff's counsel had a right in this instance to seek out press coverage, but that does not change the fact that he is burdening the court with unnecessary motion practice just so that he can secure some cheap and transitory media attention. The facts relevant to a determination of this motion are set forth in both the Bernstein declaration and the accompanied declaration of the defendant. Now the argument. Defendant should be permitted to file late motion to dismiss the amended complaint. At the outset, we noted that the current procedural posture of this case is unusual because, in contrast to most motions of this type, it has not been filed after the clerk has actually entered a default. Hence, there is no entry of a default by the clerk's office, which defendant can seek to vacate. In other words, plaintiff counsel is forcing defendant to make this motion because In violation of established standards of courtesy, he has refused to grant defendant a short extension of time to answer or move against the amended complaint. So what they're saying is they were late, but because Tyrone will not allow them an extension, they have no choice but to file this letter. That has nothing to do with why you were late. And he's saying under normal circumstances, attorneys would have been able to work this out behind the scenes and grant someone an extension. Why would Tyrone do that? You are already stating that he's seeking out cheap media publicity. You are already undermining him as an attorney. You are already attempting to paint a picture that he is greedy, money hungry, and that this lawsuit is frivolous. So why should he cut any breaks? Why should he work with anyone in that instance? Miss Mary, what is it that you're talking about? You say they didn't give him much time to respond. Who are you talking about? Are you talking about Tyrone, or are you talking about Nicki's counsel? When you said, well, they didn't give him much time to respond, did they? I mean, I understand. I think with Miss Mary and you guys, she is entitled to her stance. I think Miss Mary, she tries to see both sides of it. And I'm not sure what her stance is on the case, but I think she tries to see, both sides of it. So I'm not sure. Are you saying Tyrone didn't have time to respond? I really don't know. But I know that Nicki Minaj had 21 days to respond. Tyrone is saying, why should we give you more time when you guys already had 21 days? We went over that in the beginning of the video, that they had 21 days to respond and they did not. They were late. So anywhere else, I don't understand. If you are defending your plaintiff and you're defending your defendant, it's your job to stand firm on what the laws are. Nicki Minaj's counsel is bringing up this law and referencing that law. And because Tyrone would not grant them an extension as a courtesy, why? This is serious. This is a serious lawsuit. Both sides they don't like each other. They have no interest in working anything out with each other. They have no interest in working anything out with each other. So Tyrone is not going to give them any time to respond to anything because he wants to win. Why would he work anything out with them and run the risk and risk the chance of Jen losing her case? He's for his plaintiff. He's for her. He's not going to give them any more time than what they already had. And like Tyrone is saying, you go ahead and explain to the court why you believe your client is above the law. Any other person that this would be happening to, they would be required 21 days, period. Presumably, plaintiff's counsel is relying upon the fact that the clerk of court has no discretion to refuse to enter a default, but that would only result in defendant making a motion to vacate the default pursuant to Rule 55C, thereby resulting in litigation of the same issues which defendant seeks to pursue in a motion to dismiss the amended complaint. Rule 55C provides that the court may set aside an entry of default for good cause. There is abundant good cause here. In the first instance, there is good cause to vacate entry of default when a plaintiff fails to properly serve a defendant with the summons and complaint. So they're saying that this should be thrown out. The default should not be taken into consideration because Nicki Minaj was not properly served. In the absence of proper service, the putative defendant has no obligation to plead or otherwise defend as required by Rule 55A. Here, defendant has submitted a declaration demonstrating that she was not properly served with the summons and complaint. According to the affidavit of service filed by plaintiff docket number 14, service of defendant was purportedly accomplished on September 15, 2021 by her process server personally serving a copy of the summons and complaint upon her husband and co-defendant Kenneth Petty, who was described as a black male, 40 years old, 200 pounds, black hair, brown eyes. However, defendant has submitted a declaration stating, I am advised that plaintiff has filed an affidavit of service from a process server who claims that my husband and I were served because he personally handed the summons and complaint to my husband, who he describes as a black male, 40 years old, 200 pounds, black hair, brown eyes. The process server is not telling the truth, as this never happened. In fact, my husband is approximately 5'9" and weighs no more than 175 pounds. Further, there is no person who resides in our house or who was present there on September 15th, 2021, who fits the description contained in the affidavit of service. Apart from the failure to effect proper service upon defendant, there are additional reasons demonstrating why there is good cause to vacate a default. Because defaults are generally disfavored and are reserved for rare occasions, when doubt exists as to whether a default should be granted or vacated, the doubt should be resolved in favor of the defaulting party. In other words, good cause should be construed generously. Because Rule 55 does not define the term good cause, we have established 3 criteria that must be assessed in order to decide whether to relieve a party from default or from a default judgment. These widely accepted factors are: number 1, whether the default was willful; number 2, whether setting aside the default would prejudice the adversary; and number 3, whether a meritorious defense is presented. Other relevant equitable factors may also be considered. For instance, whether the failure to follow a rule of procedure was a mistake made in good faith, and whether the entry of default would bring about a harsh or unfair result. So basically what they're saying, they are asking that they show good cause and not accept this by default, because it would be a mistake, because Nicki Minaj did not willfully, she's saying, respond late. She's saying that it was an honest mistake. She did not obtain counsel timely, and it was miscommunication. And she's saying if the default would be found, it will bring about harsh and unfair result, because $20 million is a lot of money. So she's saying $20 million from a default judgment would be harsh because we filed it late. But that is the rule. The rule is you had until 21 days, period. Although the factors examined in deciding whether to set aside a default or a default judgment are the same, courts apply the factors more rigorously in the case of the default judgment. Also explained in this proposed letter seeking a pre-motion conference, defendant's counsel believes that the amended complaint is also subject to dismissal because the court lacks long-term jurisdiction over the defendant. They're saying that they don't have no jurisdiction over Nicki Minaj because she lives in California. And the bulk of this crime, what Jennifer, the harassment and everything that she's saying took place, she said, mostly in Georgia and New York. It didn't take place in California. Nicki Minaj lives in California. Her husband lives in California. And if they were harassing and doing all of these things, they live in California. And Jen said in the complaint that she suffered most of her infliction and stress while she was in Georgia and New York. So the jurisdiction is being argued. However, given the urgency of this motion and the limited time in which he has been forced to prepare it, counsel believes that he has a Rule 11 obligation to conduct further investigation of the facts and research of the law before committing to making a motion on that ground. Here, defendant's declaration demonstrates that her failure to timely respond to the amended complaint within 21 days of the date of its alleged service was not willful. Nicki saying she did not willfully not respond in 21 days. She says her failure to respond to the complaint by the date, which the plaintiff claims was my last date to do so, was the product of a series of innocent miscommunications. After learning about the complaint, I sought out recommendations for a lawyer in New York. On September 22nd, 2021, Mr. Bernstein was recommended to me and we met on a Zoom conference that next evening. At the end of that conference, I believed that I had agreed to Mr. Bernstein representing me, and I told him to work out the financial details with my manager, Angela. From that point on, I believed that Mr. Bernstein was my lawyer and that I would hear from him when he needed to speak with me. I note that I have not had extensive experience with court cases, and I did not know that I was at risk of default while waiting to hear from Mr. Bernstein. But your husband is very experienced with court cases. Y'all knew that y'all had a lawsuit against y'all because it was all in the blogs, it was all in the press, and you were all over social media. But what you want us to believe is that you were focused on other things and you had no idea. So you mean to tell me people at your home, they didn't let you know? If you're saying that Zoo was not the one that was served this summons, then why didn't anyone tell you that a server came there and served someone legal paperwork for you and Zoo? That's a lie. Zoo is the one that was served, period. And you don't think that when that server knocked on that door and Zoo answered that door, that he didn't ask him, was that his name? And he said yes and took that paperwork. And now that y'all want to try to get out of this, y'all want to try to lie your way out of it. From that point on, I believed that Mr. Bernstein was the lawyer. I did not learn until October 12th when I received papers concerning a default that Ms. Kowalski had not understood that I had approved Mr. Bernstein as my lawyer, and therefore he had not been retained. So you trying to say that you didn't get your paperwork till October 12th. That's a lie, because these court papers was not filed and they weren't documented by October 12th. This is October 11th. This is the certificate of default that was entered into the court. If they did this on October 11th was a Monday, how did you get the paperwork on the next day? How did they send you the paperwork the next day? Even if they sent it out by courier, or even if they sent it out by mail, you wouldn't get that by the next day. You would at least got it by the 13th. You wouldn't have got it by the 12th. That's a lie. That's a straight up lie. And we all know how the mail works and how when you get served and all that, that's a straight up lie. Mr. Bernstein, so then she says, I did not learn until after the 12th when she received papers concerning the default. But how would you receive papers? And you said, Mr. Bernstein was not available to speak with me until after the evening of October 12th, at which time the misunderstanding was cleared up and Mr. Bernstein agreed to represent me upon approval of a retainer agreement and the payment of his advance retainer. So this is how you know she's lying, okay? Because she said she did not learn about the default until October 12th. Okay, well, here's the lie. See, this is why you got to look at the timestamps and you got to look at the fucking receipts, because this is the lie. All right. Here is the judgment of default that Tyrone submitted to the court. He submitted that on October 11th and they entered it into court. You know, anytime you take something to the court, they stamp it and they log it in, right? Now, the only way you would get that document, the only way Nicki Minaj would get that document is through her attorney. So she says that she did not know about this lawsuit until she received papers on the 12th. But how did you get these papers if your attorney was not retained until the evening of October 12th when you paid him the retainer? How did you not know that you had a lawsuit when this shit was all in the media? So that's how you know that's a lie. So you're going to tell me that you retained the attorney, and once you paid him the retainer, he then gave you documents. That's not how that works. If that was not your attorney, you didn't retain him until the 12th, he would not be able to get those documents until after the 12th. He would have had to be retained on the 12th, and you said you didn't talk to him until the evening. It says Mr. Bernstein was not available to speak with me until the evening of October 12th. So where did you get these documents from? Could it be the documents that you were served, that you already had? The lies, the lies, the lies, the lie, the lie, the lie, the lie. That's a lie. The only way you can get court documents that fast is through an attorney. This shit was just filed October 11th. How you get it the next day if he was not your lawyer until the evening of the next day? There's the lie right there. Girl, stop. My failure to respond to the complaint was the product of an innocent mistake, and I asked the court to excuse the delay so that I can defend what I believe to be an entirely frivolous case which plaintiff counsel has brought against me in an effort to use my name to generate publicity for himself. Defendant's explanation of the reasons for her purported default renders it impossible to conclude that she engaged in conduct which can be deemed willful under the Second Circuit's blah, blah, blah. Mr. Bernstein confirms defendant's accounts of the facts. And then they give definition of a law, whatever. The failure to file an answer was the result of a miscommunication within the law firm representing defendant in this matter. Thus, there is no evidence of willfulness. Moreover, if the defendant did in fact default, she did so at a time when she was not represented by counsel. So she's saying, if it is going to be found that I defaulted, I didn't have counsel because I didn't obtain my counsel until the evening of October 12th. As the court held in Enron, as a general rule, a district court should grant a default judgment sparingly and grant leave to set aside the entry of default freely when the defaulting party is appearing. Also, the fact that this motion has been filed less than 48 hours after she retained counsel and only 9 days after the alleged due date for a response to the amended complaint further demonstrates that defendant's purported default was not willful. Drawing all inferences in favor of the moving defendants and noting the relatively brief period of time the moving defendants were in default, as well as the prompt application to vacate the default, the court finds that the default was not willful. And that is them reading a law, saying, comparing a case and saying why it should not be willful, okay? So if you just keep going through this, they're citing different cases, and then they get down to the end and it says, as for the second factor, prejudice to the plaintiff, to be considered under Enron, delay alone is not a sufficient basis for establishing prejudice. It's again shadowing another case where they actually vacated the default. Rather, it must be shown that delay will result in the loss of evidence, create increased difficulties of discovery, or provide greater opportunity for fraud and collusion. Vacating the default judgment will not cause substantial prejudice to plaintiff, whereas here the case is in its infancy and the parties have not yet engaged in discovery. Finally, third, on the issue of whether defendant has meritorious defenses to the amended complaint, we respectively refer the court to the proposed pre-motion conference letter attached as Exhibit A. In addition, we note that the plaintiff's failure to state a claim for which relief may be granted may constitute a meritorious defense. Conclusion: for the foregoing reasons, together with those set forth in the Bernstein Declaration and the defendant declaration, the court should grant defendant's motion and permit her to file the proposed pre-motion conference letter annexed as Exhibit A to the Bernstein Declaration. Ciao. Whew. Summing it up, it's basically Nicki Minaj and Kenneth Petty are alleging that they were not properly served. Nicki Minaj is alleging that she was not properly served. Nicki Minaj is alleging that the gentleman that served the summons, served someone that was not Kenny. It was not Kenny. And he served both summons. He gave both to this Kenny person. That was not Kenny. So Nicki is saying she was not properly served. So how can I have a lawsuit filed against me? And how can you rule in favor of default because I was not properly served? I didn't willfully not answer to the lawsuit because I didn't have counsel. It was a miscommunication between my manager and my lawyer that once I got off the Zoom call that night with the attorney, I told him to work it out with my manager, work out the financial with my manager. And at that time, my manager misread the situation. She did not pay the attorney. And it wasn't until October 11th, after Tyrone Blackburn filed a motion for Jen to win this case in default and get the $20 million because they did not answer to this lawsuit. It was only then that Nicki Minaj attempted to get counsel. And where's my lawyer? I thought I had this lawyer. Why don't I have this paperwork? Because I received a paper after the 11th on the 12th in the morning. I received paperwork that said I had a lawsuit filed against me and that they found in favor a judgment is going to be filed in the amount of $20 million because I didn't answer in time. So then I picked up the phone and I called Mr. Bernstein's office, who was not available to speak with me until the evening of October 12th. But how did I get the paperwork on October 12th if I didn't obtain counsel until the evening of October 12th? So how did I get this paperwork? You can only get court documents through an attorney. Where else are they going to send it? And now, if the court sent it to you, you wouldn't get it the very next day. So that is a bold-faced lie. There is no way that Nicki Minaj did not have counsel. There's no way that she got paperwork the very next day after it was filed on her own. She got that letter, she got that paperwork because her attorney said we didn't file, we didn't do anything, and they have entered a default. And by the way, let's take another look. Let's just take one more look at something. Let's just take a look at that email. And let's just for the sake of it, I just want to make sure and see what was the date on that email. Okay. So the lawyer, Nicki Minaj's lawyer, sent this email to Tyrone Blackburn on October 13th. Why didn't he send the email to Tyrone Blackburn on the 12th in the evening? Why didn't he send it until the 13th? He's saying, I expect to file a notice of appearance tomorrow on behalf of Nicki Minaj. I'm aware that you filed a request for certificate of default on October 11th. I'm writing that you voluntarily withdraw your request. So if you were retained by Nicki Minaj on October 12th in the evening, why didn't you draft that email to Tyrone until the 13th? That's because y'all been knew that you were found, I guess, guilty by judge of default. Y'all been knew. And she just finally gave you the go ahead. Okay, go try to work it out with Tyrone. Go try to work it out. Go try to work it out with Tyrone and see if he can give us an extension. And Tyrone said, hell no. Hell no. And when was this article? And the article was published on the 14th, where Tyrone did, the back and forth with the Daily Beast. So it just doesn't sit right with me that Nicki Minaj would really play in our face like that and say that she didn't know that she was being sued and that it was just a miscommunication on behalf of her and the attorney and the manager. But you didn't have any miscommunication with Andy Cohen when y'all was trading, bantering back and forth on Instagram on who was going to host the Potomac reunion, and you was throwing it out there that you would like to host you wasn't wasting no time being on social media when you wanted to lie about the vaccination when you're asked, no, you're vaccinated. There's no way that she was on the Real Housewives set and not be vaccinated. She knows that she's vaccinated. She just don't want to tell the public that she vaccinated because that was that was a diversion tactic. That was a diversion tactic to begin with. So you're not going to play in my face like that, Nicki Minaj, and really sit here and say that you don't see what the fuck going on in the blogs, what's going on in the press. The Real did a goddamn interview with Jen. You don't know anything about this damn lawsuit. It's all over the media, and you are all over social media constantly, but you have no idea that any of this is going on. And then you want Tyrone to give you an extension? You're going to have your lawyer reach out to Tyrone begging for an extension? Like he supposed to just drop everything and give you an extension? It's his job to win for Jen. It's his job to make sure that Jen comes out on top and get the money that she deserves for the harassment that she's been having to go through. It's her job. It's his job to win the case. Both of these sides, they are extreme enemies. Why would they try to work anything out? You're late. That's good for them. A default is good for them. It was good that you didn't answer. It was good that you would be found guilty by default. Yes, that's good for Jen. So why would he give you time? Why would he grant you an extension? No, I would have told you the same thing. Hell no. The law stated that you had 21 days. It's not my fault that your client don't have it together. Does she care more about being on social media trolling? Does she care about her own legal situations? We all know that shit is a lie. She knew she had a lawsuit, period. So I gave y'all the tea. There goes the receipts. For those that are just joining us, we have 130 people in the chat. Go ahead and hit that like button. It's free. It don't cost you a dime. Go ahead and hit that like button. Go ahead and subscribe to the channel while you're at it. Because we're going to follow this case all the way to the end. I don't care what the outcome is. We are going to give it to you as it develops. Anytime a motion is filed, anytime something is entered in the court, anytime they have an appearance, a date, we're going to cover it. We're going to follow this case from the beginning to end, and we're going to always have the court documents. Now, like I said, I try to lay it out. I'm going to give you my opinion. I'm going to give you my opinion because, yes, I really believe that this was done. I believe that Jen was intimidated. I believe that she was harassed. I believe that she was, harassed and bullied by Kenny and his goons and Nicki Minaj. Because the way this all materialized, Jen didn't ask for this. Jen was living her life. They went on Queen Radio and they brought this to the forefront because they wanted to show off and they wanted to be hugged up in their room, Nicki ass all out. They wanted to show off. Kenny wanted the world and his friends and people to know that he was booed up and hooked up with Nicki Minaj. And when Jen saw that shit, she knew what was coming. She knew that they were going to be after her because they already were behind the scenes. She knew it was going to get worse. They divulged who Jen was. They painted a false narrative that Jen was a white girl. Jen never stepped out of the shadows and was forced to defend herself and tell her side of the story until Nicki Minaj and Kenneth Petty, they exposed who she was. Period. Jen was not letting anyone know that she was the victim. Nicki Minaj and Kenneth Petty exposed her. Period. So, as this case continues, as this plays out in the courts, we will be covering it and we will be following it. We will give you the tea first, right here on the Sweet Pea Diaries. We will digest, dissect, and like I said, if there's addresses and stuff like that, I'll try to blot it out beforehand. But yes, that's it, guys. That's it. This has been another edition of the Sweet Pea Diaries. I have an interview that I'm late for, that I gotta go tape for. So I gotta get dressed, I gotta change and get into my interview gear so I can tape this interview. If you guys are watching, I'm coming right now. I'm sorry, I'm coming right now. I had to get this video done because my people was already telling me about this. You know, a couple people had came in the comments and in the chat last night talking about, you know, they answered, and I said, yes, we will, you know, we will have a whole video, execute an entire video, set aside an entire video for this case. Because when I talk about Cardi B, I cannot put Nicki Minaj in the same goddamn video with my queen Cardi. I cannot do it. So this has been another edition of the Sweet Pea Diaries. All of the new subscribers, we are almost at 8.5K. Right now, we are at 8,000, I believe, 474 it was before I went live. We are almost at 8.5K, at 8,500. We are almost there. We are on the road to 10K. Let's try to make it there by the end of the year. Let's try to make it there before the new year. Let that be my New Year's resolution, that I'm going to make it till 10K, that I'm going to keep being a great content creator. I'm going to stay out of drama. I'm going to stay out of mess. That's my New Year's resolution, even though I do that anyway, child. Hey, Hubbard. Hey, girl. So y'all go ahead and run up them likes. We need 100 subscribers. Y'all go ahead and hit that subscribe button. And when you hit subscribe, make sure you hit all and you click that bell up there, because, honey, YouTube be unsubscribing my subscribers. So every now and then I need y'all to just check once a week and make sure that you are still subscribed, okay? Because sometimes they be hating on you, girl. I don't know why they hate on Sweet Pea. I follow the rules. I'm never doxing people. I'm never up here arguing with people. I follow the rules. Why are you messing with my subscribers? I ain't even got 10K. Y'all messing with my subs. So, yes, can we get 100 subs, please? Go ahead and hit that subscribe button. Hit that subscribe button. Y'all be sure to like, share, and subscribe. Thank you for joining. This has been another edition of the Sweet Pea Diaries. This has been another, the People's Court, honey. This is the People's Court. This is Sweet Pea's Court. Matter of fact, I think that's what I'm going to start calling these segments. Sweet Pea's Court. Who's on the goddamn docket? Sweet Pea's Court. This has been another edition of the Sweet Pea Diaries. Sweet Pea's Court right here on the Sweet Pea Diaries YouTube channel. Y'all be sure to like, share, and subscribe. I'll see you next time. Catch you on the next video. Bye.